Uh, I
Calling 2022 CR 0.
This case starts with a very serious charge: injury to a child, which in Texas is a felony offense. Right away, the court explains that the punishment could range anywhere from 2 to 10 years in prison, along with a large fine at SO. Before we even hear the details, we already know this isn't some small argument or misunderstanding. The law treats cases involving violence against minors extremely seriously, and the defendant here is about to enter a plea, which means she's accepting responsibility under a plea agreement instead of taking the case to a full jury trial. But as you'll see in a moment, once the judge starts digging into what actually happened, things get very uncomfortable very quickly.
The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
What the state is offering here is something called deferred adjudication. That means the judge is delaying a final conviction as long as the defendant follows strict probation conditions. If she completes everything successfully, she may avoid a permanent conviction on her record. But notice the important part. The court adds an affirmative finding of family violence. That carries serious consequences. It means she cannot legally possess firearms, and it can also affect things like custody rights in family court. Even though this deal avoids immediate prison time, it still places very heavy restrictions on her life moving forward.
Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State offer states one in attachments.
We did review them, no, Judge.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding you guilty as you've applied for
The defense attorney tries to paint a picture of someone who made a mistake years ago, but has since stabilized her life. He mentions she has steady employment and hasn't had further problems since the incident. But then the judge asks a question that immediately changes the tone of the courtroom. Because according to the police report, this wasn't just an argument. The allegation is that an adult woman approached a teenage girl in a park, grabbed her by the hair, and physically attacked her. And the judge wants to know something very simple. Why would an adult do that to a 14-year-old?
To her local hotel. She's gainfully employed. She does other side work with other groups that she can tell me about if you'd like to hear, because I'm not familiar with the groups that she works with.
So how old was your son's girlfriend?
Method.
This is the moment where the entire situation becomes uncomfortable. The judge is reading from the police report and referencing video evidence that allegedly shows the attack. But the defendant suddenly begins distancing herself from what happened. She even suggests she's never really seen the girl before. That's a huge problem in court, because she already pled guilty to the charge. When someone accepts a plea, but then starts denying the underlying behavior in front of the judge, it raises serious concerns about whether they're actually taking responsibility for their actions. And judges notice that immediately. Now we finally hear her reasoning. She claims she believed the girl was a bad influence on her son, mentioning drugs, running away, and other behavior that worried her as a parent. But frustration and fear don't justify violence. Parents can absolutely be concerned about who their children spend time with. But the moment an adult physically attacks a teenager, the situation crosses into criminal territory, and the judge is about to make that point very clearly. The judge's response is direct and leaves very little room for excuses. He asks a powerful question. How does beating up someone your son is dating make you a good parent? That moment really cuts through the entire justification the defendant tried to give. In the end, the court doesn't send her straight to prison. Instead, the judge orders 6 years of deferred adjudication, strict probation conditions, and 30 days in jail. It's a punishment designed to hold her accountable while still giving her a chance to stay out of long-term prison, but only if she follows every condition. And it sends a clear message that even when emotions run high, adults are still responsible for how they respond.